So we continue to read the case of Horace Richards versus Geraldine Ramsay-Facey. So here we see the importance of having documents as evidence of adverse possession or evidence of persons allowing other persons to stay on a land or at a house, or passing down ownership to their children or grandchildren. Now, submissions. Mr. Williams submitted that the issue to be determined by the court was whether Everard Ramsay had left a will, as a result of which the grant of administration should be revoked. That's a grant of administration to Mrs. Ramsay-Facey. In support of the evidence and validity of the will, he highlighted the evidence of the attesting witnesses and stated that the veracity of this account had been rebutted by any medical evidence produced by the defendant, that's by Mrs. Ramsay-Facey, in support of her contention that the deceased was unable to make or sign a will. Okay. So remember, Mrs. Ramsay-Facey is saying that her father, or her brother, would not have been able to make such a will because of the stroke. And that stroke had affected his brain. It was cerebral hemorrhage. So he would not have been mentally capable of signing a will. That's her contention. He made reference to the sole asset identified in the will, which the defendant, Mrs. Ramsay-Facey, insisted had belonged to her father, and asked the court to note that no documentary proof had been provided that the property did not belong to Everard Ramsay. So Mr. Horace Ramsay is saying that Mrs. Ramsay-Facey and her niece are saying, but not showing any evidence that his stepfather did not own the land. They're saying he did not own the land, but they failed to show any documentary proof. Counsel argued that even if Everard Ramsay had not been the purchaser, he had become the owner by his exclusive and undisturbed possession of the same for over 13 years. Okay. He occupied the property without being disturbed for over 13 years. So he becomes the owner by adverse possession. Now, here, he questioned the rule. He questioned the true motives of the defendant, Mrs. Ramsay-Facey. So remember, we're looking at the submissions by Mr. Richard's lawyer. He questioned the true motives of the defendant and submitted that she did not need to administer the estate of Everard Ramsay, as on her account he possessed no asset. Oh, so they caught her here. Mrs. Ramsay-Facey is saying that she was the administrator of the defendant, of the deceased estate, but at the same time saying that the deceased had no assets. So what is it? How is it that she became administrator of an estate that the so-called owner did not have? Interesting. He contended that if her true intention had been to distribute the estate of Percival Ramsay among the prospective beneficiaries, then her application should have been made in respect of his estate Mr. Williams argued that Mr. Richard's lawyer argued that the defendant's position where the claimant was concerned, or where the claimant was concerned, was based on a faulty legal premise, as while she had sought to exclude him from the process, Everald's interest, that's the deceased, interest in the property would have passed to his wife, that's Mr. Richard's mother. The interest would have passed to his wife. It would have passed to Mr. Richard's mother, the claimant's mother, on his death. And on her death, this would have passed to her son. So Mr. Richard's lawyer would be saying that Mr. Ramsay's interest would pass to his wife on his death, and then on her death to his son, Mr. Horace Richards. He claimed, he asked the court to act to revoke the grant, as there had been no meddling in the estate up to this point. In her submissions, Miss Grant posited that there were 6 legal issues which fell to be considered by the court, and she outlined these as follows. Should Mr. Horace Richards be granted the cancellation of the grant made to the defendant? Was the defendant entitled in law to make an application for a grant of administration in the estate of Everald Ramsay? That was Mrs. Ramsay-Facey entitled in law to make an application for a grant of administration in the estate of Everald Ramsay? Is the court entitled to determine if the purported last will and testament of Everald Ramsay is authentic, bearing in mind all the circumstances? Is the will an authentic will? What are the implications if the will was not deemed to be authentic? If the will is not found to be authentic, would the grant of administration be deemed valid? If the grant of administration is valid, what interest, if any, would the claimant have in Herring Lane? All right. So, here, she asks the court to accept the evidence of the defendant, of Mrs. Ramsay-Facey, the brother of the deceased, and her witness, and highlighted that no documentary proof had been presented by Mr. Richards to show that the property had been owned by Everald Ramsay. Well, no. She relied on Section 4 of the Interstate Estate and Property Charges Act as laying the foundation on which Mrs. Ramsay-Facey had applied for and obtained a grant of administration. She also made reference to the Wills Act in respect of what factors should be considered by the court to determine whether the document was in fact valid. Okay, here. So, these are the considerations to be made. We're going to look at the analysis and discussion in our next video.